So a very warm welcome, first of all, everyone who took us time and investing your time here. We really welcome you all once again. This is Reed Kaur, student convener for Society for Constitutional Law and Human Rights. Today we have an amazing panelist with us who will be discussing on the agenda of interpretative constitutionalism, efficacy of preamble, and its legitimacy in democratic state. So, firstly, I would say that we are very fortunate to disclose this very idea of panel discussion, that is 20th panel discussion on the very topic of preamble, because as yesterday we all know that India celebrated its 75 years of independence, and we are fortunate enough to tell you that Society for Constitutional Law and Human Rights have successfully completed 3 years of its establishment, and this would have never been possible without the support of our faculty convener Ashutosh sir, who are here with us today. And it would be really great if we can hear something from you, sir.
Good afternoon, everyone. So this is our first session in this semester. So welcome Reet and Krishna. So they are the new convener and co-convener, Reet and Krishna. So they have taken the charge from Shikhar and they have taken the charge from the Shikhar. So best of luck, Reet and Krishna. So today's topic is very, very relevant because as she has already suggested that we're starting with the preamble. So in recent times, there are many controversies or issues which are related with the preamble. So for example, some people demand that the term secular should be removed, but some people say that preamble is now a part of the basic structure, so you cannot change anything. So few days back, I was teaching the constitutional law class, so I read the preamble again. So then I went to the Constituent Assembly debate. So as we know that it starts with "We the people of India." So at that point of time also there was a debate in the Constituent Assembly. So some people wanted that it should start with "in the name of the God." Thereafter, some people also wanted that it should have the name of Mahatma Gandhi. So at the end there was a vote happened. And then in the voting, I think 62 people voted that we should start with "We the people of India." So they rejected this motion "in the name of the God." So that's why some people say that even God lost in the Constituent Assembly of India, because the God have lost in the Constituent Assembly of India. So no doubt this is a very, very relevant topic. So hoping for a good session. Yes, Reet, you can continue now.
Thank you so much, sir, for providing us the insight for today's agenda. And just to give a quick brief, I would say that the preamble gives guidance and states and the purpose for which the Constitution of India has been framed. And as we all know that preamble was drafted at the very last, but I placed at very first. So this is the whole idea that brings the debate and gives the ideology to our participants also to analyze this, because if we take the example of landmark judgments also starting from A.K. Gopal and Indra Berubari, where preamble holds the limited applicability of its very object. So the whole idea is very debatable because the ideology varies from person to person, and as we all know that every individual holds different ideology in context of preamble and the constitution, because this is something we cannot interpret in a restricted manner, and this needs to be a way more flexible while interpreting. So the whole idea that the society implies is that to think out of the classroom, that is out of the box, and take some challenges and discuss the analogy that presents the current situation and current time, because as we all know that we cannot bound law in one diameter, so we need to think out of the box and go further with it. So by this I would like to pass over the today's session to Ashish sir, moderator for 20th panel discussion, to give us a very detailed aspect towards discussing with the ideology with different panelists today. And by this I would give it to Ashish sir. Over to you, Ashish sir. We really welcome you all to the panel today. Just a second, sir. We'll just solve this.
Krishna, can you accept?
शिखर अभी वो कौन है इसका?
Krishna has, she has made the host.
अच्छा, वैसे मैं भी हूँ कोच, तो मैं भी कर ही दूंगा। सर भी हो गए, ठीक है
जी। Thank you so much, Reet. Thank you, Krishna. Thank you all the students. Thank you the society, and thanks to Professor Ashutosh for creating a good forum. And I'm really obliged that you have handed it over to me. The topic is good. Topic is very interesting. Constitutionalism. In the functioning of a government, I believe, or in the running of any complex system, discretion is a must. People may argue, and we may also debate over, but that will only be, unwise consumption of time. Discretion is a must. Who will exercise that discretion? What will be the parameters of right and wrong? Who will be the decision maker? Ultimately, who will exercise power on what issues? These things happen to be at the core of concern many a times. The development of civilization and the development of polities have been towards making it objective. And it is visible. It is visible. Let's take few examples. When a system starts, at that time, in the beginning of legal system, the importance of discretion is undeniable, and it does exist. I'm taking only two examples. One is bail, and the other is very small example. I'm not comparing it to be as big as constitutionalism itself. And second is grant of injunctions. No one can deny that these two aspects shall have, some discretion to be exercised by the chair. But as and when the legal system grows, it all moves from some degree of subjectivity towards objectivity. Now, in what situation bail can be granted, in what situation bail cannot be granted, and in what manner discretion has to be exercised, and what all shall be aspects on which individual subjectivity shall prevail over. All these things start getting settled down. This is how the growth and a time in the development of a legal system also counts towards including more of objectivity. Who will exercise the discretion? Means, is it going to be the executive or the court, or who? The idea of constitutionalism, which is written by David Feldman. Chaube Saab is here. He will explain more about David Feldman and his ideology, which says that constitutionalism is more about putting limitations on the government. It is more or less a limited government. Government has all the powers, but government is not unlimited. It has some limitations. And what would form those limitations? It is the written, objective, express provisions of the law. And those laws are not going to be ordinary laws, because making of the law is also in the hands of the government. So what law? It has to be some superior law, special law like the Constitution. And this is how constitutionalism is established. To understand a little more about it, law is also an instrument which is of political outcome. Law is an outcome of political functions. So it is in the control of the government. There are two things, therefore. Governments have to be representative, and there have to be certain other parameters also, like what the government cannot legislate on, what law cannot be made, what government can make law, what government cannot make law over. So two aspects come up. One is representative character of the government, and second is the empowerment of the population. The empowerment of population is more or less reflected in the part 3 of the Constitution, which is in the nature of restrictions on state action. Means what the state cannot do. And most crucial of the stately sovereign functions is lawmaking. I believe this is a clear indication of constitutionalism existent within the constitutional setup of India, and maybe that it can be seen as an advantage of a late evolved constitution. Here, for the benefit of people, means all of us, I thought of setting context. I have not done anything like defining it or explaining it or putting a discourse on it. I have just set the context and tone of the discussion. Now, I would request our esteemed panelists to kindly one by one introduce themselves and give a one-liner on their understanding of constitutionalism. It is not supposed to be a strict one-liner. It can be a two-liner also, just to give their understanding of constitutionalism, what they think of. Then we'll come to the next agenda. Yes, please. Chaube sir, it would be great if you could start.
Thank you, sir. I think I'm audible to all.
Yes, at least to me, you are loud.
Okay. Thanks a lot, sir. And good afternoon, Pram, first of all. And thanks to Ashutosh, sir, and team Society for Constitutional Law and Human Rights for inviting me as a panelist. School of Law and this society has a special place in my life, and UPS is home, so it's always a nice feeling. And now presently I am associated with DAV PG College Dehradun, Department of Political Science, as assistant professor. And thanks to all the team members of the society for completing 3 successful years. Because I was involved in all these things, so I know that this thought process and doing this kind of things continuously for 3 years is a huge task, and it's really commendable. So thank you, team of the society. Thank you, Ashutosh sir, and thank you, Verma sir. Okay. First of all, when I heard this topic, 2 things were there in my mind. Although the topic is very relevant, as Ashutosh sir pointed out, but one thing is there which I could make of it, that legitimacy, if we are talking in the practical sense, then it's a different thing. But legitimacy of the preamble, when we are reading this topic, interpretive constitutionalism and efficacy of preamble and its legitimacy in a democratic state. So coming from the political science background and having a theoretical perspective on most of these aspects, what I could make out of it, एक छोटी सी incident है. Once Advani ji said something regarding government of Manmohan Singh using the word legitimate. So later on, उनको वो शब्द वापस लेने पड़े थे. संसद. I think I'm audible.
Yes, sir. Yes, sir.
हाँ, thank you, sir. So जब आप देखेंगे legitimacy, the whole word legitimacy. So from my side, what we can see is more of the efficacy. और वहां से जब आप चीजों पे constitutionalism, interpretive constitutionalism से trickle down आके इसको what I can assume of this, Atul Kohli, well-known scholar, in his book Democracy and Discontent, he talks about governability. And we also know that procedural versus substantive aspect of the democracy. So जब हम इस पूरे मुद्दे को देखते हैं और शिफ्ट करने की कोशिश करें, तो I think in the current scenario also, we can see it from the deepening of democracy also, from this perspective, what I can make of it. तो जब आप चीजों की बात करते हैं जिसको कार्ल शिमिट what he is calling the fundamental principles, और एक बड़ी अच्छी सी बात है, if Ashish sir allow me, and I can digress a bit, actually not digressing, actually in today's time, when you look at in your neighborhood, yesterday's event, Taliban coming to power, all those things, so एक बहुत current debate philosophy और political science में भी है और जगहों पे भी है कि intelligence has to do nothing, nature don't want you to be intelligent. ठीक है, तो जो आदमी की सारी रेशनैलिटी है, इंटेलिजेंस है, उसका वास्तविक जीवन से कोई ताल्लुक रहा नहीं. मे बी आई एम साउंडिंग अ बिट निहिलिस्टिक लाइक फ्रेडरिक नीत्शे, लेकिन ये कई चीजों में आप देखेंगे अब प्रीएम्बल क्यों इंपॉर्टेंट हो जाता है. जैसे कि लॉ इज द, फॉर मी एंड फॉर मेनी अदर्स, लॉ इज द bedrock of our nation, and preamble is the most important thing in from that very perspective. दूसरी बात जो मैं कहना चाह रहा हूँ कि एक इससे ये भी स्टेटमेंट ले सकते हैं, जब हम डेमोक्रेसी की बात करते हैं या और चीजों पे जो लीगल एस्पेक्ट से हट के बात करते हैं, तो लॉ इज द ओनली सेवियर. तो लाइक सर पॉइंटेड आउट मैनी थिंग, सो इफ यू गो फेज वाइज and looking at the judiciary, functioning of judiciary, so initially there was this textual thing, okay, AK Gopalan case and all those things. Later on we come to structure, the Keshwanand Bharti case and the basic structure doctrine, and then we come all to the purpose, like very recently regarding 377, or regarding bringing the office of CJI under the ambit of RTI. So many sort of changes and many interpretations are there. So what I would like to suggest here, and as what I could make of it, the whole discussion, we have to see that so far in a interpretive manner, जैसे प्रियम्बल का एक जो बहुत फंडामेंटल एस्पेक्ट है आप किसी भी कंट्री में, ठीक, वो आपको है इंटीग्रेटिव नेचर. ओके, so how far these words socialist, secular, okay, all these things so far after these 75 years and all, okay, we are able to realize the democracy. It's more about the realization of the basic things regarding democracy, कि हम उनको कितना समझ पाए, कितना वो प्रैक्टिकली हम देख पा रहे हैं. और एक चीज होगी which can be a later part of the discussion, कि suppose all together from those electoral reforms, RTI, a big thing, citizen charter, social audit, decentralization, all these 73rd, 74th, so all these things
कृष्णा वो विजय सर है, उनको बनाओ, होस्ट बनाओ.
all these things are going to have a very serious impact on the lives of all, because at the end of the day it's about we the people. And interestingly, you only find we the people means people exclusively only in this preamble, not in the later things means anywhere in the constitution. So from my side, I would like to really dwell upon these particular aspects when I am looking at the topic. Thank you.
साहब, आपसे काफी उम्मीदें हैं अभी. I'll come back to you, and thanks for the version that you have given about constitutionalism. Now I'll request the next panelist, Mr. Udit.
Excuse me, sir. Just a minute. Dean sir is here with us, so it would be really an opportunity.
Let us continue. Let us not have any formalities, right? So I just wanted to wish you all good luck for this. My apologies for being late. But it is good that we have initiated again this particular activity under SCLHR, and I'm quite excited to see the panelists. And thank you, Vikas, for accepting our request. Good to have you again amongst us. And
thank you, sir.
Definitely, Dr. Ashish is moderating the session, so it is going to be a wonderful session, I'm sure. Actually, I'm engaged with another event today that is on, urban development, municipalities. So I'm speaking on that particular dimension, because that is again a constitutional area, which has been underworked, I must say, because a lot has not happened in that area. Unfortunately, though it is a constitutional body, but not much has happened there. So probably quite exciting things coming out there. Maybe in future, we will have a seminar program on this urban development and law. That is something which is quite interesting. So my all best wishes to all of you. Please proceed and continue with this. I'll be here for some time and hearing you all and enjoying the discussion. This is what was from my side. And in future, I would like to request that kindly don't bother yourselves with formalities. This is an academic forum. And idea is, डीन है, ठीक है, कोई बात नहीं है, डीन है, अपनी जगह पे है, वो पीछे अपना बैकग्राउंड में सुनेंगे, लेकिन प्रोसीडिंग्स को कभी डिस्टर्ब मत करिए, ठीक है? All the best to both of you, and kindly continue.
Thank you so much, sir.
Thank you.
And I also wanted to confirm your presence and your intervention will never disturb us. And we are happy by your presence. Thank you so much.
No. Thank you. Thanks a lot, and thank you for your humility, Dr. Ashish. Thanks a lot.
Thank you, sir.
Pleasure.
Thank you so much, sir.
So if we are back to the session, means the discussion, may I request Professor Udit to kindly put forth his, I think, a brief introduction. Maybe not, because he needs no introduction. It's from among us, but the one-liner about his idea of constitutionalism.
Thank you so much, sir. Sir, so first of all, congratulations to all of us for the 75th Independence Day that we recently celebrated. Again, third anniversary for SCLHR, and coincidentally, it's the 4th anniversary of my teaching career. So today is the day I started my journey in academics. So
congrats, Udit. Congrats for that.
Congratulations, Professor Udit. You are definitely an asset in academics.
Yes, sir. Glad to hear from you. It's great to be back on the discussion forum of this society. The topic about interpretative constitutionalism. Dr. Vikas sir also referred to the article written by Mr. Chetan Chandrachud, where he mentioned of phases of constitutionalism, from textualist to structure to eclectic, and then finally to the purpose approach, and where he silently also mentioned about the fifth approach, which he's skeptical about, that we might again land up into eclectic approach, where he's made a subtle conclusion on this point. So I'll also be referring to that article because I think that gives good insight about the way in which courts have been understanding constitutionalism. And definitely from a legalist approach, constitutionalism, we study as an idea of limited government. And it's a very, very dynamic concept. It has to be looked in light of the constitutional aspirations, the aims, and we can go to Keshwanand Bharti number of times, time and again, to find out certain basic structure. But I think the biggest essence that would come out can be explained in one word, which is constitutionalism. So there cannot be a bigger feature to the Constitution of India than constitutionalism itself. And I'll be talking on these lines. So briefly, I'll end my submission here and looking forward to hearing from all the panelists and speaking further. Thank you.
Thank you, Professor Udit. Thank you. Now, the next panelist, Professor Ruby. Kindly let us know of your perspective of constitutionalism and plus your introduction. If you feel like you also need no introduction.
Thank you, Ashish. Thank you, everyone. Thank you, my dear colleagues and my dear students. When we speak about constitutionalism, I definitely believe in the limited definition, which is constitutionalism is nothing but limited government. But these limitations that we talk about, these limitations should be internally conceptualized or internally driven. When I say internally driven, I say that every country has a different social, cultural, political setup. And they should devise these limitations based on that social political context. We need not to look at West and take those standard limitations of the West and apply on our model of Eastern countries. Because our history has been very different. We have been the colonized one rather than the colonizers. So since the history has been very different, the struggles have been very different. So the limitations on the government will be definitely very different. I would take just one example and then I will conclude. Specifically when we talk about secularism, which is a very essential pillar of constitutionalism, people generally tend to have this understanding that secularism is separation of state from religion. We need not to have that separation. Not every country need to have that separation because this is an understanding of the West. Their history has developed that understanding. But when you look at our country, when you look at India, we definitely had made that separation, but the state had to also actively protect the faith of the people, has to give minorities that push so that they can also be mainstream. So yes, we adopted a very different model with secularism. And similarly, the whole idea of constitutionalism is again of limited government, but those limitations will have to be country specific, will have to be cultural specific. The reason being that we have different histories. So that is my basic understanding of constitutionalism. Thank you.
Thank you.
So.
In fact, you touched upon a very essential part of it. It is limited government and what should be the limitation and what not. That is a good indication to give here. Now, someone has written in the chat, constitutional law is about the modus operandi and policies and procedures in administering our country. I have a very small thought on it, which I generally share in my classes also. I will take an opportunity of sharing it here. What is constitutional? Constitutional law. Not before coming to constitutional law, I'm saying what is constitution? Constitution of India. It's maybe a thought which may not be sounding very good to all, but Constitution of India is what all India constitutes of. I think what all India constitutes of, and that is why Indian Constitution is lengthier than others, because it is more towards completion. It will deal with three major aspects of it. One is territory. Territory, I suppose, will include all natural resources, I believe. Second is population. That is part 2 of the Constitution, citizenship. Who all will be Indians? Who are the people of India? Without having an eye over who are the people of India and just beating around the bush, we the people of India, we the who all are included in this we. This may also have some touching points on the idea of secularism, because when Article 5 of the Constitution was being drafted in the Constituent Assembly, there was a lot of debate who all should have the by birth right to citizenship. I'll not get into all that. First, territory, including natural resources. This is what I understand. Second is people, and third is the legal system. From part 3 onwards, the entire Constitution is only towards establishing a legal system, which is constitutional legal setup, which is again to be seen in 2 parts. One is the setup part of it. The setup means the machinery, the offices. Like Article 52 says, there shall be a President of India. Like Article 79 says, there shall be a Parliament for the Union, which shall consist of so and so, the President and 2 houses, namely to be so and so respectively. Like there shall be a Supreme Court, etc., etc., etc. Mechanism, the setup part of it, the tantra. Yes, machinery. Second aspect of this constitutional legal setup is constitutional ideology. The constitutional ideology will majorly comprise of part 3, that is fundamental rights, and nonetheless part 4, the directive principles, and further nonetheless part 4A, the fundamental duties. When we try to understand constitutionalism, means government has to be limited. It will have 2 aspects, as already made clear by our panelists. 2 aspects. One, the government has to have representative character. People have to have a participation in the formation and functioning of the government. And second, what the government cannot do, restrictions on all possible prospective governmental actions. 2 major aspects. I think this is nothing big, simple. Now, going back to little theory, and I would request on that point, how far do we relate it with the idea of limitations of on the government, means say a government which is unlimited, the rex, the convergence of all powers, which may or may not go arbitrary. Convergence of all powers versus limitations arising out of the social contract. That means referring to John Locke and Thomas Hobbes. Chauvesop, if you could have some brief input on this, if that would be great, or something around this. Social contract kahan tak relate kar sakta hai constitutionalism se? Means actually the idea is not only about government being limited, it is about what limitations would be genuine. So will the limitations arise out of the social contract or what? So here John Locke versus Thomas Hobbes. Sir, please.
Yes, sir. Thank you, sir, for bringing these things in the light. So as I mentioned in the starting itself, and as sir hinted, means rest of the panelists also talked about that it's more about the limited government. So when initially I was talking about the social settings, how and in the words of Granville Austin, actually, that a seamless web was the challenge. Okay, along with the democracy and unity and integrity of the nation, throughout the preamble and throughout the Constitution, you will find that a social revolution was at the core of everything. And nowadays, there in the theoretical, means political science and elsewhere also, means legal and everywhere, rewriting the social contract, that we have to see that when we are making or keeping people at the core of everything, we the people. Suppose one interesting aspect is also there, which I find missing, as I mentioned initially also, that after this you don't find, means initially you have put we the people, And suppose in the American Constitution you find somewhere pursuit of happiness or something like that, but unfortunately we don't have those things in Indian Constitution. But at the same time, when we look at the history of we look at India since independence, okay, so we find that decentralization and all those things, they have done a lot. But it's more about like in today's context, when and referring back to this social contract theorist Hobbes and Locke, and later on Rousseau. Okay, so the consent of the people, okay, or suppose in the Rousseau's concept, the concept of general will, okay. So in today's time, when I was referring to Atul Kohli, or when in general also I'm talking about deepening of democracy, because these are the aspects where from the interpretive part you are coming to the realization of these values. So what on ground we have done so far as a country, what we have achieved, and as a political system what we have done, because there is a debate that the substantive means people arguing with the substantive perspective will say that that's a part of the government, that's an aspect of the governability where things have gone wrong or these things. But at the end of the day, we have to see that executive has a big role to play, and ultimately it will be reflected. Like in the when you look at the different indexes of democracy, you will find that India features flawed democracy as flawed democracy. Those are different indexes and different concerns are there. But the consent of the people, that how this we the people is in day-to-day life is reflected there. So whether it's a you are taking it from Locke, that limited government is there, or representative democracy is there. So nowadays the big question, if like I said, ki when we will be dealing with this aspect, so we'll be definitely looking towards the social revolution, that socially these reforms which has helped to come to bring people in the center of the things. So from that very perspective, we have to see that how the formation of public opinion is there, like media control. In the words of Chomsky and others, you can to see how much clear and how correct is the public formation of public opinion. And another thing related to this is that I think I have time.
Yes, sir. You are speaking so good that we cannot put any limitation on your government of discourse.
No, sir, because I thought someone was questioning about time. So this one crucial aspect is there, that how this public opinion is shaping up, because at the end of the day, when we are deciding everything on the name we the people, and we are talking about limitations, so we have to look into these aspects. These are the crucial things which we have to discuss, at least when we are looking from the side of democracy, because we are talking about a democratic setup at the end of the day. So this is one thing. And another aspect which is important, that other than this media control and formation of public opinion, when you are taking something from the social contract tradition, you have to see that how far these values which we have kept there as the means lighthouse regarding everything, which is at the core of everything, that how far your laws and everything is able to tackle the real problems, means the political system is churning. Like one crucial aspect is also there regarding the first past the post system. This FPTP system is itself a big question mark in India. And as it is a well-known fact and saying regarding democracy, that हम इससे बेहतर कुछ नहीं बना पाए, इसलिए इसे खराब नहीं कह सकते. जैसे आप तब तक बुलक कार्ट को डिस्कार्ड नहीं करेंगे जब तक आप इंजन को नहीं बना पाए थे, ठीक है. तो वो एक प्रॉब्लमेटिक फीचर है. लेकिन जब आप इसे प्रॉब्लमेटाइज करने जाते हैं और सोशल कॉन्ट्रैक्ट ट्रेडिशन से लिंक करके पूरा पब्लिक ओपिनियन, उसकी फॉर्मेशन, बिकॉज जब आप सेकुलरिज्म की बात कर रहे हैं या फेथ को, आप जो इनिशियल कॉन्स्टिट्यूएंट असेंबली डिबेट्स भी थे कि भाई गॉड को क्यों ना रखा जाए, गांधी को क्यों ना रखा जाए, या जब आपने इसे 1976 में ऐड किया दो चीजों को, तब आपने क्यों नहीं ऐड किया, या जितने भी आप एट द एंड ऑफ द डे डिस्कशंस देखेंगे या जो सुप्रीम कोर्ट के रिसेंट वर्डिक्ट्स भी देखेंगे, तो आपको ये लगेगा कि लॉ इज ऑल्सो समवेयर इज रिफ्लेक्टिंग अपॉन द कंबाइंड इमोशंस ऑफ द कम्युनिटी, मतलब जिस हिसाब से। लेकिन अगर वो इमोशन ही प्रॉब्लमेटिक है, वो सही तरीके से रिप्रेजेंट नहीं हो रहा है, बिकॉज एट द एंड ऑफ द डे यू आर गोइंग ऑन द इलेक्टोरल पॉलिटिक्स। अगर आप वहीं से सब कुछ डिसाइड करने लगेंगे, तो इस कॉन्टेक्स्ट में व्हाई आई फाइंड दैट दिस इज अ वेरी रेलिवेंट डिस्कशन एंड दिस टॉपिक सर्व्स अ लॉट ऑफ पर्पस, बिकॉज आप ये फाइन लाइन यहीं से देखेंगे कि सब कुछ, जैसे समटाइम्स in today I use in my classes also and somewhere in the general discussion that sometimes government misuse the sovereign power. जो पावर आपने, जैसे आप कई जगह स्पेशल पिटिशंस फाइल करने की बात आती है, तो इंडिविजुअल हैज नो चॉइस बट गवर्नमेंट हैज डिफरेंट काइंड ऑफ राइट्स, स्टेट गवर्नमेंट्स एंड सेंट्रल गवर्नमेंट, तो वो भी तो मिसयूज ऑफ सॉवरेन पावर है। तो सॉवरेनिटी को आप जिस तरीके से देख रहे हैं, या जो आपकी विल ऑफ द पीपल जैसे रिप्रेजेंट हो रही है डेमोक्रेसी में, आई थिंक these 2 or 3 crucial aspects are there. Ki first, how we are looking at the formation of public opinion, the role of media and all when we are dealing with the larger aspects, because lot many things are already there which talks about the limited government, constitutionalism as highlighted by different panelists and sir also. So in the contemporary situation, in the means regarding the political system and regarding the democratic framework, we have to see these points and how far these social revolutions, which are a positive aspect actually, RTI, a big thing. So law making, law से क्या changes आ सकते हैं और वो कैसे कोई सामाजिक क्रांति ला सकते हैं, we have to understand these things, and more for the students कि वो social revolution is at the core of everything in the constitution. Thank you.
Thank you, Chauvin sahab. It was really enlightening. And I have just one observation, if you please allow me. How can
Yes, sir.
be a law which has a purpose of bringing in social revolution? Laws can never intend to bring in social revolution. Reform can be the purpose.
Yes, sir. Means initially in the vocabulary of Granville Austin, when he was talking about that seamless web thing, so largely we can say that he was talking about maybe the vocabulary is there, social revolution, but social reforms are there, that RTI is a reform and all these things.
I agree, and I stand corrected. Thank you so much, sir. I really apologize having missed one of our panelists, Mr. Shrestha Srivastav. I request Shrestha to just chip in and unmute and give a brief introduction, though you also need no introduction, Shrestha. So
No, sir,
a brief
that's not
introduction help many, and your idea of constitutionalism, and then we'll proceed further.
Thank you very much, sir. And first, I'd like to thank the society for inviting me as a panelist. The last Thursday, I was a part of this committee, and now today I'm as a panelist. So what I can say is I'm a representative of this society as a member of panelists. My idea of constitutionalism has always been that the limitation on the government is not only one aspect which we have to deal with the constitutionalism, but it goes way beyond that. In order to define that what constitutionalism means, it is pertinent for us to differentiate the constitutionalism into 3 aspects. That is the modern, the legal, and professional constitutionalism. And that is the area which I will be dealing later in my discussion. And when we deal with the preamble and its relation to the democracy and constitutionalism, the best article, or the best author which I always recommend is David Hume's Interpretation of Constitutionalism, where he called the preamble as a constitutional science of any particular authority. Therefore, this particular area I will be dealing later in my discussion. Thank you.
Thank you, Shrestha. So now moving on to our next panelist, Professor Udit. May I request to directly come on to the say main agenda. Constitutionalism, we have made it a topic, interpretative constitutionalism. So how far, Professor Udit, you think in our constitution we have been able to establish the regimes of legislative constitutionalism versus interpretative constitutionalism? Means I believe we would like to hear you on legislative constitutionalism vis-a-vis interpretative constitutionalism, and which one is a bigger contributory to the regime of constitutionalism in India? Professor Udit, please.
Thank you, sir. Thank you so much.
I believe my topic is clear. Question is clear.
Yes, sir, absolutely clear.
Thank you.
In the discourse, it will anyway get covered. What I'm going to state, it will get covered. Thank you, sir. So, as I mentioned, that constitutionalism itself is one of the biggest objectives behind, or one of the things that was envisaged behind crafting the Constitution of India. And it certainly goes a long way. It has different perceptions. And I mentioned of a writing by Mr. Chetan Chandrachud, where he mentioned of 4, stages of constitutionalism. The first one being textualist, which is very closest to being legislative constitutionalism, as Sir has talked about. The initial cases like Sajjan Singh, all reflect of this kind of a value of constitutionalism, where the judiciary was very textualist in its approach. In fact, if you look at the reading in A.K. Gopalan case, one of the observations of the judges, and this is part of the judgment, that even if the legislature would have prescribed a punishment as cruel as someone being boiled to death, even the judiciary would have executed it that way. It would have not questioned the manner of execution, because that is beyond the purview of the judiciary to challenge. And from there came a different trend of the second phase of constitutionalism, which we can call as recognizing the structure, and wherein we see, I think, Golaknath as the beginning, and then I think a lot of cases, but I think the pivotal is Keshwan and Bharti, where we actually sat down and thought to decide, let us fix for once that what all we recognize as places which should not be interfered with, and which all ideals we recognize as something which should not be interfered with, or rather this was the idea in the mind of the judges, that these basic structure are some things that if taken away would deny the constitution of its own original identity. And therefore, if we understand it this way, we started recognizing structure from there. In Golaknath, we paid great attention to fundamental rights, and it was again overruled. And in Keshwan and Bharti, we recognized several features as basic structure, from where I think the second form of constitutionalism that Sir mentioned of, which was interpretative constitutionalism, I think the birth actually started there, where we started looking, at the spirit and not just the text, where we started recognizing judiciary as the true custodian of the constitutional values. And in the same light, we'll have to see that, the role of Supreme Court, the role of judiciary becomes very, very important. I think the constitution makers had great faith in the judiciary, while, designating the powers under Article 32, while providing the powers under Article 142 of the Constitution, Article 136 of the Constitution. I think their original idea was embedded in great faith upon the judiciary of this country, and, giving it the role of being watchdog of the constitutional values and the protector of the fundamental rights of the people. And therefore, whenever we talk of constitutionalism, the way in which judiciary engages itself with this concept becomes very important for any vibrant democracy, particularly in that of India. So maybe if I can, just skip that 4 phases of constitutionalism and come up to one recent incident that happened last year, where, the former CJI, Justice Ranjan Gogoi, sworn as a member of Rajya Sabha. So this kind of an incident is a very, very heartbreaking incident for any constitutional student, for any believer of constitutionalism. I mean, to me, it was a disaster in a way, because the same judges who are talking of concepts like constitutional morality, when their actions are brought into question, they view it from the very strict legalistic perspective. They view it from a cutthroat legalism. And when they are sitting on as judges and deciding matters, they talk about things beyond legalism, things like constitutional morality, things like, basic structure, which are not clearly reflective. In fact, the word constitutionalism is nowhere present in the Constitution itself. But without it, it will lose all significance. So, I mean, such incidents keep us in business, keep us, raising questions on, are we, then we'll have to look at it as a great phenomena, not just as a separate incident. We'll have to see that if constitutionalism as a value has to be protected, then the protectors of the constitutionalism also have to be protected. And therefore, independence of judiciary becomes a very, very important thing. And, so then I think in contemporary context, I would request students to, research a bit more on these things and maybe come up with some suggestions on post-retirement, limitations. And I think one of the panelists, Mr. Sresht, I've read his article. He has written a complete article on limitation of post-retirement jobs with regard to judges, and that is also published in NLU Shimla, I think, journal. And it's a good article. We should go through it, and we should question these things, that, these things really take away the confidence of, of people of India on the concept of constitutionalism itself, because the very people who are prima facie faces of constitutionalism or protectors of constitutionalism, who are adorning the highest judicial office of this country, must also live with certain limitations. And their argument should not only be limited to strict legalism, but the concept of morality must be reflective in their approach itself. Now, coming to the third phase, which was talked about, which was called as eclectic approach, or eclecticism as the third phase of constitutionalism. I think there were two observations by the author here. He mentioned that first, that till I think 1970s, there were huge benches constituted on each relevant matter. And after that, the Supreme Court, started keeping benches of ordinarily 2 to 3 judges. And very, very pertinent constitutional matters were referred to 5 judge bench. So a kind of jurisprudence started emanating that was very much, maybe haphazard or sometimes even contradictory. So he mentions of a phase that simultaneously 13 Supreme Courts are operating in one day. We cannot have just one court, but then the point is, the more fragmented it becomes, the more scope of arbitrariness or the more scope of eclecticism comes. And certainly, if we do a very thorough research on this aspect, which I, during my master's, got an opportunity to do, we do realize that we have developed contrary jurisprudence, and we have, deviated a great deal from the concept of stare decisis and precedents, and a lot of factors which were not in accordance with the earlier observations of the court became important. So that is there. And then the fourth stage is talked about, which is purpose. So Mr. Vikas was mentioning about social revolution, and definitely social justice as held in PUDR versus Union of India. That social justice is the signature tune of the Indian Constitution. I really stand by that statement that, if you look at Article 17 of the Constitution, abolition of untouchability, Article 23 and 24, rights against exploitation, talking about begar, abolition of forced labor, and maybe abolition of child labor, and such incidents, then we do realize that, our constitution, or in fact the whole policy of positive discrimination from Article 15 onwards, then we can figure out that our constitution is not just a charter of a state, it is a charter which is giving us a leap into a new social order. It is at least envisaging a new social order. So we can use the word social reform or social revolution, doesn't make a difference here, but social justice remains at the heart of the constitutional philosophy. So anything which upsets this contribution and gradual growth of social justice within the Indian polity may also be held as a limitation, may also be read as a limitation on the, on the idea of limited government. And then, yeah, I've already mentioned that, while talking about protecting constitutionalism, we also have to see the ancillary features, or maybe talk about protecting the value, protecting the protectors of the notion of constitutionalism itself. I mentioned that incident. Now, I'll take just 1 minute on the point of the most cherished value, which is democracy, a term on which books can be written and still it could not be explained properly. So democracy I see as a byproduct of certain things. It's not a starting point of a polity, but I think it is something which gets generated as a byproduct of some continuous efforts and practices. Fairness, transparency, respect for dissent are some of such things. And we have often referred to media as the fourth pillar of democracy. And in the contemporary context, I see that this particular fourth pillar of the democracy is becoming the hollow pillar. It is actually losing its significance a great deal. And because of, I would say, the deliberate inaction, which is almost criminal, that the Indian media is doing, I think this democracy is up for a huge setback. I would request the students who are listening to this, maybe you can go on YouTube and sometime just, Google on YouTube, you can just find out some videos of news reporting that used to happen in 70s and 80s on national TV or DD News. So, I mean, sometimes I really miss that. Sometimes when I open television for hearing news, I feel very sad and I have a great anxiety to switch it off as early as possible, because I hardly see any kind of news reporting. It is, I mean, we have lost the whole thought of, conveying news to the people of this country. In fact, what Professor Vikas was talking about, that shaping public opinion, I think media is playing a very, very negative role in this direction. We can clearly recognize from the faces, we can clearly recognize from the first word used by the journalist that what this person is going to talk about throughout his discourse. This is very problematic. I think the fourth pillar of democracy is in great danger, and it is putting the whole, whole building of democracy in danger. Because, ultimately, if a pillar collapses, then building will have a problem somewhere. So we'll have to look at these things. With regard to working of legislature, yesterday only our present CJI Justice Ramana has mentioned of sorry state of affairs that is prevailing in the legislative houses, that now we don't see elaborate discussion over the bills. Now we don't see informed discussions over the bills, which could ultimately help the courts in finding the legislative intent. If we don't have good debates, counter arguments, and good submissions by learned members and hardworking members, then ultimately the judiciary will have least content to interpret and find out the true legislative intent. And I think this would somewhere impact also the interpretative constitutionalism. I mean, it would have some connect with the idea of interpretative constitutionalism. So I think with 75 years of independence, we should keep reviewing the public institutions, especially the legislature, the judiciary, and the constant effort of judging the lawmakers and judging the judges has to be prevalent. And when I say legislature, because we are bicameral, I mean, fair share of executive gets included there. So I think in contemporary discourse, there is a great need to keep reviewing our constitutional values and keep revisiting them, and try and finding out maybe the fifth phase of constitutionalism, which is assimilative of structure and purpose, and which can undo the eclectic approach to a great deal, or which can bring some synchrony in the jurisprudence. That is my submission. Thank you so much.
Thank you, Professor Udit. It was really brainstorming, but the ideas which I had for the concluding part of the discussion, I'll just take a detour in informing Professor Ashutosh, then I'll continue. The meeting I had at 4 that has been postponed, and I'll continue. So
That's
I
good,
think
sir.
thank you so much. You that the discussion you have brought in, this is inviting something. I have some points to say. One, constitutionalism needs to be protected is debatable. Constitutionalism is what? Is it something physical? Is it some idea which can be endangered, or is it something which will come out of all dangers and all possible adversities? Because it is not limited to any individual, any time, any space, anything. What is constitution in that case? I have given my idea. Constitution is what India constitutes of. That has a constitutional legal regime, which will have two parts: the setup, which is always amendable, which is always open to change and may need change. Second, the constitutional philosophy, the constitutional ideology, that is invincible. This is not going to change. If it changes, that will only be a mere adaptation to the changing aspirations of the need, time, and cultural transition. Nothing more is going to happen. Next point. Constitutionalism is a reality. Governments are limited. Since the Bill of Rights itself, it is confirmed, means the statements that Thomas Jefferson had made, we need to have a certain set of basic inherent inalienable rights, the effectiveness of which is dependent upon the outcome of no elections. Despite the governments being representative, they don't have the capability. Even the people of India don't have capability to change it. This is one thing. So limitations would be there, but what would be the content of that limitation? This will be in debate. That's why we are debating. That's why we are discussing. This is true. But constitutionalism needs protection at this moment. Media has become something which is in danger. The fourth pillar is in question, and all that starts at what time? I'll not mention that time. I believe your thoughts have confirmed since when you have started feeling endangered in our polity. By the way, so far as your Justice Gogoi is joining Rajya Sabha is concerned, I'll tell you what limitation should be there. So far as it is decided by the makers of the constitution and by the legislators, maybe through amendments, all that forms part of the legislative constitutionalism. Yes, legislative constitutionalism puts certain restrictions over the judges, what they cannot do post-retirement. Yes, and there is further under debate whether they should be allowed to take up further assignments or not at all. That is under debate. But you want it to be a part of interpretative and scholarly constitutionalism. That scholarly constitutionalism is a third term which I am just coining, to my understanding, that they should be disallowed from swearing into popular houses. This is nothing happening for the first time. I know two examples. Justice H.R. Khanna did swear in for Rajya Sabha immediately after emergency because he had resigned. Case was also there. Yes, he did swear in. Yes, it is a different thing that he resigned. He did not complete the term. He did resign. That was his personal reasons. Second thing, the most celebrated, I find him the most celebrated Supreme Court judge.
Rangnath Mishra?
No, not in my example. It was not Rangnath Mishra. It was Justice V.R. Krishna Iyer. Justice V.R. Krishna Iyer was a legislator in Kerala Assembly. He was a
Then he
legislator
became.
in Kerala Assembly. He did swear in as a minister in the Kerala executive government. Yes. And then after he did swear in as a judge in the Kerala High Court. But no one did question it because he was a person of unquestioned integrity. And that was the time when people, that generation, used to live up to values and aspirational values. Time has changed.
Rangnath Mishra sir also joined Congress after he retires from the Supreme Court. So he went to join the Congress and then he went to the Rajya Sabha.
If I have two examples, one example will also come, and maybe that there are few more examples. I'm not totally aware of. I had some hint that Rangnath Mishra also joined politics,
Yes,
but
sir.
I'm not sure whether he did swear in into any house or not.
Yes, sir. He was a member of Rajya Sabha.
After his term with this National Human Rights Commission. This
Yes.
is one thing. So everything coming to danger just because Justice Gogoi has sworn in as a Rajya Sabha member by Varadhast of PM Modi. This cannot put constitutionalism in danger. This is one thing. Now, coming on to our important thing, that it says, okay, constitutionalism begins. Professor Udit has said, I'm just giving reflections and I'm hopeful that I'll be accepted. Constitutionalism begins with judicial efforts, and judiciary is the protector of constitutionalism. I beg to differ. There is nothing like versus. I use the term legislative constitutionalism versus or vis-a-vis interpretative constitutionalism, but there is nothing like versus. I'm simply taking one example of Article 12. When Constitution was made, the basic regime, the foundations of constitutionalism were being established, even if it is used or not. Yes, the next agenda that I'm going to give to Professor Ruby is about judicial review. But Ruby, before you speak, I'm taking 2 minutes. Yes, how far judicial review is going to stand as an instrument of constitutionalism, effectuating constitutionalism? Is it written anywhere in the Constitution that judicial review shall be an instrument of judicial interpretation, or they will do something of this kind? Nowhere. I don't see. Jurisdictions are drawn, and why they are drawn? Because it is a concerted effort of all the stakeholders, be it legislative constitutionalism, be it interpretative constitutionalism, be it scholarly constitutionalism. We all are stakeholders, and we tend to explore the real being of the Constitution. Legislatures have explored it and they have expressed it. Their explorations may be faulty, may not be faulty. Their expression may be faulty. That's why there is an invitation for interpretation. I'm giving you one example of Article 12. Article 12 uses a word. Everyone knows it's a very simple example, other authorities. And everyone writes with a lot of enthusiasm that this is vague. Do you think the makers of the Constitution were unaware that this is vague? They all knew what we are doing is creating a vague provision, but they did not intend to create a vague provision, but they created a vague provision. This is only an invitation for the judiciary to come and explore it further beyond what we have explored about the being of the Constitution. Constitution does not live only in the body of provisions. It has a spirit behind it. Here, somebody should have mentioned, I think time will fall short if we go to Friedrich Savigny. Laws are like beings. They get birth, they evolve, get mature, get old, and finally they die out. And law dies out as and when the civilization dies out. So it is directly rooted into the culture, and it lives with the cultural existence of the community. By the way, I was only saying that if law is like a being, बच्चे को जन्म दिया किसने? Yes. पाला पोसा किसने? Teachings provide की किसने? Yes. And he was carved out as a professional by whom? Means different stages, there may be different stakeholders. Maybe there are a litigant who files a case. That petitioner is also a stakeholder who contributes to the exploration of the real spirit of the Constitution, or say constitutionalism. If it is not so, then I have a further example to cite, which I'll do after two speakers, preferably. I hope I could make my point clear. So it is not like only judiciary has done the survival or evolution of the constitutionalism. It was started, the scratch was made, and they had to take it forward. That was their task, which they have done. If they have done it with a lot of action, enthusiasm, and zeal, they are known as activist judiciary. However, this activism of the judiciary is also a matter of criticism. At times, in the zeal of judicial activism, judiciary has been seen standing on the extremes of their jurisdiction. Is it not? I'm not saying they have crossed it. They are being seen standing on the extremes of their jurisdiction, and it has happened. and those points may be debatable, but that is bound to happen. Now, presuming that my questions are understood, it all originated from the statement written by one person. It is modus operandi, procedures, and all. It's not just procedure. What law can be made? If you refer to the old case of A.K. Gopalan, yes, what is the procedure established by law? Is it only any procedure laid down by the process of lawmaking, or it has got some subjective qualifications as well? There are those qualifications, and every provision of Constitution is bound to live up to those. And I believe this sets the tone, takes it forward. Udit, I hope we have reached the same page.
Absolutely, we are always on the same page, sir.
No. If we are always on the same page, then discussions will become irrelevant.
Sir, may I have some reflections over your reflections? I'll just speak 2 lines.
नहीं उदित तभी रुक जाओ क्योंकि बाकी 2 लोग हैं, फिर 4:30 पे हम खत्म करना है. So we have to take some question also.
Okay.
We have to take question also because already it's 4:08 now.
Because it has come from the committee who are the organizers. So let's respect. Professor Ruby, now your reflections on the role of judicial review, its very existence, the constitutionality of judicial review itself, and how far has it been able to uphold constitutionalism, particularly interpretative constitutionalism in India.
Thank you, sir. I've been listening to Vikas, sir. I've been clearly listened to what Udit sir said, and even to your reflections. How we moved from social contract theory, and then we moved to the role of media in manufacturing consent. And that how is that troubling our democracy? How is that troubling the idea of constitutionalism? Now, I'll begin from that point. When you said that social contract theory, we have very well included that social contract theory in our constitution in the form of preamble. We, the people of India, when we say we, the people of India, it's not only those people who were present when the constitution was being drafted. It also included the past generation who were part of that national struggle, the people who were part of the Constituent Assembly or people at that time, and even the present generation or the coming generation. So this contract that people signed in the past is still relevant today. But when we talk about a contract, we have to look whether the principles that we have enshrined in that contract or the terms and conditions that we have kept, whether the party with whom we have signed it, whether that party is fulfilling those principles or not. So this is where the preamble comes into the picture, and the preamble keeps reminding us, or it becomes very necessary for us to connect with or keep in touch with the preamble or connect. It's not only the judiciary, it's also the legislature, that whenever they draft a law or whenever they try to bring an amendment to the constitution, it's important for us, it's important for them, the legislatures, that they look at the principles, they look at those aspirations which people have shared with them, and then do the necessary interpretation or do the necessary amendments. So I agree with you when you said that it's not versus, it's not interpretative constitutionalism versus legislative constitutionalism. I think combined together is what is constitutionalism about. Constitutionalism, and I would also disagree with Udit here, that constitutionalism is not in danger. Constitution can be in danger because constitution in itself is a product of constitutionalism. We need not to have that word in constitution, because constitutionalism, again, is the idea with which we signed with this theory, or we signed this contract with the government. That is the whole idea of theory of social contract. It will give you certain rights and you protect. So, and those rights that we are giving, there are certain limitations that we, and preamble very well laid out those restrictions. Justice, equality, fraternity. And when we very well, one line that I like the most about the preamble is that it is that we give to the people fraternity, assuring the dignity of an individual. This is my favorite from the preamble. that yes, we can believe in commonhood, we can have brotherhood, but in that community attitude, we should not forget that everyone who's part of that community is an individual. So we have the nation, but at the same time, make sure that you protect the fundamental rights. Now, definitely legislature has placed, we as society has progressed. And I remember as a student of law, when I started reading the Constitutional Assembly debates, I read that so many debates were happened while drafting the preamble. Some speakers mentioned in the very beginning that in the name of the gods, some said, okay, if you're mentioning God, write goddesses also, almighty. And so many discussions happened on each word. But as we progressed, as we became a little confident with our independence, and then the emergency period came. And in such hastiness, 2 words were included without any discussion and debate. This is where the legislative constitutionalism went wrong. That the drafters, the intention with which they drafted the preamble, there was so much discussions because the word solemnly affirm, it says that after discussions and debates, we will have this. We cannot just put after arbitrariness, we cannot include words. So as we progressed as society, we as individuals, we as society have changed. And that was the first incident. We started doing wrongs with the constitution, but nobody paid much heed to it. And then comes the era of 1991. We through other principles which were mentioned in the preamble, we conveyed to our people that we will have social liberalism in this country. We will not go with classical liberalism of the West. We will have social liberalism. That with liberalism, there will be government who will be taking care of your welfare, your rights, your basic things. But here comes 1991, and we started slowly, we started to forget the ideal of social liberalism. This is where the preamble needs to be recalled. This is where the preambles needs to be connected with our the drafting, or as the legislature needs to connect. The judiciary needs to connect. But 1991, and you see the market taking over everything. Your basic services like education, hospitals, all these are now being privatized to a larger scale. And to this also, the judiciary doesn't come and say, okay, this is not how, because you promise social liberalism, this is not social liberalism. So judiciary is also the question about judicial review. How far are we able to use it to protect constitutionalism? Judiciary has been doing it. Judiciary has done commendable judgments, has given, but there are certain things which are very basic things, or the principles of preamble which needs to be protected. Somewhere judiciary is lacking. Now coming to the point which Professor Vikas and Udit sir also touched upon, the role of media. Okay, media was, first of all, was a self-claimed 4th pillar of democracy. It was never mentioned that it will be 4th pillar of democracy. It was self-claimed. So when they self-claimed 4th pillar of democracy, they give a tough fight in during the 1970s emergency period, and this is the reason they were gagged by the government. But as soon as 1990s period started, and we see a lot of foreign direct investment flooding our media industry, the character of the media has changed. Now the character of the media is to sell things or to do what appeal to the majority. Earlier, media was working on the principle of what Dr. B.R. Ambedkar said, the principle of constitutional morality. That these principles which are mentioned in the preamble are the moral principles. If you have to decide the right and wrong, apply these principles and see whether they are right or wrong. But 1991 onwards, media, they said, okay, we will manufacture consent from the public, but we'll do it our way. So this manufacturing of consent, which happened 1991 onwards, and as Vikas has said, and I agree with him, that when we talk about social contract theory and we talk about preamble and we say we the people of India, this consent or this will needs to be free. But the kind of role that is being played by media in manufacturing the consent, that will is no more free. So coming to the question that Ashish raised about the judicial review. Yes, judicial review is a very important tool to protect our constitution and at the same time to bring the changing will of the people also. Because as society we are evolving, we will evolve, our aspirations will change. So that aspirations needs to be included. Judicial review is one of the important tools to make sure, but ultimately it is the legislature. The role of the judiciary is to protect or is to struck down if something wrong being done. But if something new needs to be inculcated, the aspirations needs to be included. It is the legislature which needs to do it. And for the legislature to do it, we need to keep reminding of the legislature of the essential principles in the preamble. This is something that you promised to give us, and you need to stick by these. So yes, judicial review will definitely go a long way in protecting the ideals of preamble, in protecting the idea of constitutionalism, but we cannot deny the role of legislature. It is one of the important organs of the government. We have constituted it, and we just need to look at concepts. We need to look at our country. We need to look at the culture that we are part of, and then we need to develop on or conceptualize our principles. As a students of law, I would request everyone, do not just read foreign concepts and try and apply them to our Indian settings. We have, again, I would repeat, we have a different history, with different people, our aspirations are different. And one thing, before I conclude, just one thing, Gandhi gave a very good concept, or the concept that I like, of unalienated life. He said there was a debate between liberty and equality. He said equality says that you make everyone equal. Liberty says set them free. If you're setting them free, that obviously some will excel because of their merit. Okay, so inequality will definitely, during course of time, inequality will set in. So liberty and the principle of equality is somewhere contrary to each other. To which Mahatma Gandhi has written that, this idea of looking at liberty and equality is a Western idea. Okay, because they are very individualistic in their outlook. But we, in Eastern societies, we are community-oriented people. We follow the principle of unalienated life, which means we are individuals, but at the same time, we see our existence as part of the community. So we believe in the idea that if community will grow, we as individuals will grow. We never propagated the idea. इसलिए आप पहले देखेंगे, आप नई जनरेशन है, इतना आपको आइडिया नहीं होगा, बट कभी अगर आपको गांव में जाने का मौका मिले, वहां के स्ट्रक्चर को थोड़ा स्टडी कीजिए. वहां पे कभी खेती को काटा जाता है, उसके बाद गांव के कुछ ऐसे सेक्शंस होते हैं, उनको वो खेती का एक पार्ट दे दिया जाता है. Not just because they're poor, not just because they have done something for them, because again, we see that if as a community will grow, then as individuals also will grow. So when you look at the principles of constitutionalism from this perspective, then you will never find the two principles opposite to each other. So this is the difference of looking at your idea of constitutionalism from your history, from your perspective, rather than buying a foreign concept and applying it on your settings. With that, thank you, sir. Thank you, everyone, for the patient listening.
Thank you, Ruby.
Thank you, sir.
There is a question in the chat box. So
there are many questions, sir.
I saw two. One
all
is more of an
we have
opinion. I will read all of it.
sir.
It starts from here. Does Article 13 not give implied power of interpretation to courts? It does. It does. But it is not the only provision which will give implied powers, or I would rather not call it implied power. Power.
Correct.
It is very direct to interpret. And courts have been interpreting, so this is not a matter of opinion now. This is more of a thing. Now, next is the approach of preamble, both strict and liberal. This is more of an opinion. The approach of preamble, both strict and liberal, while doing interpretation of the Constitution. I find it more as an opinion than a question, so I did not take it up. How far is the social contract valid if the government in power is majoritarian in nature and the majority is living in a bubble wherein the state can absolutely do no wrong? This is also an opinion. If your presumptions are correct, if your presumptions are that government in power is majoritarian, this is a presumption, you presume it. If your presumption is correct, second presumption is that the majority is living in a bubble wherein the government can do no wrong. I believe governments face so many questions. If you want to, this question may have political dimensions, and if I start answering on that, that will also not be the same way good. So if these presumptions are correct, then there is a question whether the social contract is valid or not. And it will depend on what used to be the terms of that social contract. How far? Is it a totalitarian state? Have we submitted everything? I think not. Everything is not submitted. Even if everything is submitted, the era has developed. The legal regime has developed far beyond those, those situations. Bill of Rights did set the tone. We made our constitution much late. By that time, the Universal Declaration of Human Rights was already made, and our constitution lives up to the expectations and the commitments made in the United Nations General Assembly. So part 3rd and part 4th are there to take care of all those things. So it is no more like an absolute totalitarian and all submissive thing. There are restrictions and government is limited. The basic nature of fundamental rights is that putting restrictions on state action, what the state cannot do. So this is, I think, self-answered. And so far as the opinion part of it is concerned, I would not like to comment on that. If anyone has an opinion, can feel free to express. Any of the panelists, I mean.
Ashish sir, sorry,
Please.
but can we just hear Shresth as well, and then we'll be open to discussion because we have a time crunch for the Zoom link.
I'm just coming. Actually, one of the questions was going to form my agenda for Shresth's conversation. So I was coming on to that question only, and I was told that there are many questions. So I was duty bound to refer to all of them. That's why. Rest, I'm just coming to that. I think next question is that only. Next question is that only. Shresth, you have already made it clear as to what is going to be your perspective on constitutionalism and what you are going to speak about, which is a valuable part of our discussion. So please do that. Apart from that, this is one thing which I would like to share your views on. This is a discussion on amendments in preamble and a special discussion on word secularism. I don't see it this way. This question will be covered in the agenda I'm going to give to Shresth. It is like Constitution can never be unamendable. Even the concept of federalism has traveled some journey from constitutions being rigid, absolutely rigid, to be like rigid enough to stand federal. I'm sure people understand what I mean to convey. That means constitutions cannot be totally rigid. They have to change. They have to be changeable. Do we really believe that constitution changes, or only constitutional provisions to change? Maybe thoughts. Constitution is the same because what was thought of. Preamble is a key to open the minds of the makers of the Constitution. Preamble is the key. It's not the lock itself. Lock is where? In the minds of the makers of the Constitution. Content is in the minds of the makers of the Constitution, and preamble is going to be the key. So, is it like the instrument to open the content is more important than the content? I'm only giving it as a thought. I'm not concluding on it. So Shresth's point is, if Constitution cannot be static, laws cannot be static, and constitution is the same because it is perpetual. It keeps evolving, but only provisions change. The real content and the original thing, essence being the same. Yes, but it has to have changing provisions. It has to be dynamic. If they have to be dynamic, and the basic framework, that is the basic features, should they also not be changeable? Is it that they are static? So this is the point. I believe I could make my point clear, Shrist. So I request you to speak on this, which will answer this question as well by specific reference to secularism, even if we don't refer to it, and the perspective which you have already thought of. Please cover these two things.
Thank you, sir. So, with the shortage of time, I will not be dealing with the introduction part, but rather than I will be answering the question and also answering to your previous question, which you have put to this, sir, regarding to the question which when Justice Gagoi was appointed as the member of the Rajya Sabha. So the reason that why the constitution and the constitutionalism are threatened is not because the earlier judges have also been appointed to such lucrative posts, but because of the reason that Justice Gagoi, prior to his appointment as the member of the Lok Sabha, Rajya Sabha, was having in hand the utmost cases of great importance, like the Ayodhya verdict, these Rafael verdicts, and also we cannot neglect the fact that he was one of these particular persons who was accused of sexual harassment case. And then in that particular case, the principle of natural justice, nemo juris causa in jus sua, was violated because he himself sat on the bench and decided the case. I'm not saying that, yes, the judges should not be appointed to these particular posts because at the end, they are the person who has the legal knowledge and experience. But incidents like Justice Gagoi, Justice P. Sathavan, who dismissed an FIR which involved Amit Shah, and he was appointed as the governor of the state of Kerala. Justice Sunil Gaur, when he dismissed the bail application of P. Chidambaram, he was, and the very next day, he was appointed as the chairperson of Money Laundering Affairs Authority. All these particular instances not only raises a question of fundamental importance, but also raises a question that there has been a reasonable likelihood of biasness in the mind of judges. And this also violates the principle of justice, which is one of the most essential elements of the preamble, when it says the word justice. And when I said that I will be dividing constitutionalism into three parts, then my three parts would have been legal, the professional, and the modern. Whereas the modern deals with that not only the government, but any authority which acts to act under the ambit of rule of law. And so coming to your now question that whether the constitution should be static or not, so definitely constitution is evolving. It evolves like a grass. But what remains the same? That is the spirit of the constitution. That is the fundamental principles of the constitution always remains the same. And answering to the question with respect to secularism and judicial review, we have already seen that when the Supreme Court accepted the petition challenging the Places of Worship Act. Now, this is what I call a proxy litigation and an over-exercise of judicial review. That's why there's a need to resurrect a buried issue. And not only this, if we talk about how democracy and preamble are interrelated, then in the outbreak of CA protests, the group of lawyers in the Supreme Court premises in the unison read out the preamble stating that what is the duty casted upon them, that what is the democracy and everything else. And then we talk about when we talk about justice, a few days ago we heard that 108 years old person died when his case was admitted after 81 years he has been pursuing. Was that a justice? I would say no. Father Stan Swami, who died in prison, was that a justice to his case? I would say no. And when we talk about the limiting scope of Article 32, when Justice Bobre said that we are about to limit the scope of Article 32, it means that we are limiting the heart and soul of the Constitution. Would that be in consonance with the preamble? I would say no. So this was all my observation with respect to this particular topic, that how constitutionalism, which deals with the limitation, but also deals with each and every authority should exercise its power. And if they are not exercising their power, then it's only a blow to the democratic principles of the democracy. So that's what my.
Thank you, Shrest, for taking it the right direction. Thank you so much. There are some questions which are, yes, Mr. Udit, please.
No, sir, as I actually mentioned, it was not for you, it was for somebody else. But anyway, sir, I wanted to make two quick statements on the reflections that you gave, sir. Sir, first, that you mentioned what is the timeline that you located the danger. I would submit, sir, the danger has always been there. The danger has always been there, but then possibly I was not mature enough to realize the danger that happened in the past. But I should not shut my eyes to the dangers that are prevailing now, just because I could not comment on the past dangers. Second thing, sir, with regard to the limitation on post-retirement jobs that I talked about, sir, I made my submission in light of the jurisprudence that develops on, likeliness of bias rather than actual proof of bias. So the jurisprudence around this has developed, around bias is dependent on likeliness rather than of actual proof. So if we have to, we can bail out Justice Krishna here because he could have, impeccable integrity. This would become never ending, right, sir?
There is no need to bail out Justice Krishna here because there is no point of there's no need to bail him out. He's already out of any
Bailed out.
criticism and discussion.
Right.
The thing you have said, it was always in danger. The statement is quite conclusive. Something which is highly valuable will always be in danger because currents of whenever the content of authority is there, possibility of misuse can never be ruled out. I don't mean to say everything is corrupt, but possibility of misuse cannot be ruled out. This is why all legal systems have been struggling as to how to righteously exercise administrative discretion. This has happened more with administrative discretion, and because we are discussing about constitutionalism, and interpretative constitutionalism has got a huge role of the preamble also. It has got. So, the agenda has also come on to certain issues like legislative versus interpretative constitutionalism. We have concluded that it is not versus. It is constitutionalism inclusive of both legislative and interpretative constitutionalism, even at times including scholarly constitutionalism. This can also be a part of the same type of contribution. Now, who is infallible? Is the judiciary infallible? It cannot be. The very concept of say appeal starts with an idea that human judgment can never be infallible. There will be some fallibility. So we cannot say that merely having judicial review will always make it legitimate. It is not. It may not be. It cannot be. So both ways, both have to contribute. At times, many people may cite the judgment of Shah Banu and the subsequent legislation. What is correct? This is just an example, may not relate to constitutionalism. Someone may cite something. So the 3 points I mentioned: territory of India, people of India, and the constitutional legal regime, the legal system, including the setup part and the constitutional philosophy. You see, the territory part has a lot of discretion, say uncontrolled discretion for the executive. Whether some territory has been included or not, about this, I doubt judicial review will be done. But when it comes to resources, that's why I emphatically said that territory including natural resources. Yes, when it came to resources, MC Mehta versus Kamal Nath is an example. Constitutionalism by way of interpretation did evolve. When it comes to people, someone wants to say something. When it comes to people, that is about citizenship. CAA is an example. Whether executive discretion should stand or there should be judicial debate on it. And this debate may not be so easy to conclude on. When it comes to the legal regime, or say the overall interpretative constitutionalism, who is best correct, it can never be so easily concluded. I will just cite an example. There was a case in which the Supreme Court, it's a very famous case. The Supreme Court made an order that this is a situation which justifies the need of a uniform civil code. And court is writing, the government is hereby ordered to inform this court what are the developments achieved so far towards formulating a uniform civil code. Point number 2, it says, if not within 6 months, it should be started. And after completion of 6 months from the date of the order, this court should be informed of the developments towards uniform civil code and all. But 2 years later, in 1997, this was Sarala Muddal, everyone knows. In Dilly Thomas, court justifies that it was not forming ratio of the judgment. It was arbiter, something which is an order, which is forming. The court says it forms arbiter, not ratio. Why is the court defending? Even if it is not forming ratio, why is the court defending? Is it not that the court knows that the spirit of constitution is not relating with those orders? So Miscalculations can happen any moment by any stakeholder. So constitutionalism is constitutionalism. That is no doubt important. We all are on the same page on that. But whether legislative constitutionalism is or interpretative constitutionalism is superior, that we cannot so easily conclude, because we cannot compare. There are two different domains of the thing. I believe legislative constitutionalism is an earlier scratch. Interpretative constitutionalism is, say, maybe the next step. So that sounds like a superior thing. But in India, both have contributed to their bit. That's why we have been able to evolve as so powerful and so large a democracy. This is my concluding line. If anyone has to say something or to ask something, forum is open. Or Sir Ashutosh.
Sir. Sir, but just one thing, sir, which I want to ask, that the word which was added later on, that is the secular and the term socialism, which were added by the 42nd Amendment. So as we know that at that point of time, there was no opposition because everyone was in jail. So for example, suppose in future, just it's a hypothetical question, suppose in future the court is saying, although it's a hypothetical question, that emergency was illegal. For example, I'm saying that emergency was illegal. So does it automatically mean that those two words will automatically be removed? Because already a case have been filed in the Supreme Court regarding the whole emergency thing and compensation and many other factors.
दो बातें कहूंगा मैं आशुतोष. पहली बात तो ये कि if a law is made and law is later declared to be unconstitutional, will it be like the actions taken under that law before, still the time of it being declared as unconstitutional, will also stand deleted, repealed, and declared unconstitutional? They will stand as law till the time declared unconstitutional. Action taken under that will continue. So it's not that easy. Maybe that it may be a ground of undoing it, but it does not automatically get repealed. This is an opinion. Second thing, it's not that easy. The two words you are saying, they are like opening up a new debate. So, and we are at the beyond the boundary. So, and among us, among the panelists, including the moderator and including this committee, the most say acceptable member on the panel is Shresth. And I had thrown the question to Shresth by asking simple question: if constitution cannot stay static, how can the basic features stay static? And Shresth avoided concluding on it. Shresth, can you give a concluding line on it? Can it be so easily concluded to be static? It can never change, or it should also be open to change. I'm not saying this particular word should change. You just give us the benchmark.
Yes, sir. So,
whatever you say will be the conclusion of the panel.
Okay, sir. So my observation would have always been that the Constitution is a living document which always needs to be involved. Like Udit sir used to talk, in our first semester, we have a subject legal method, and he used to teach us the judgment of Sabrimala, that how Sabrimala is a new dimension to the word secularism. And like what Ashutosh sir just has pointed out, it's 1975 emergency declared invalid, it's illegal, then whether the word secular and socialist will be declared unconstitutional. So my answer would be that it would go then against the constitutional morality, that in order to declare illegal something, we cannot declare that those aspects illegal which had one of the essential elements of the strongest democracy, which we always point out. That secularism is one of the essential element of democracy. So no, I would suggest that.
I am not talking about secularism or socialism. I'm simply saying if constitution has to be dynamic, standards of constitution and the methods of evolution, everything has to be dynamic and inclusive. So should it not be like the basic features should also be dynamic and changeable? What would be the process? I don't know. But if they are to be changeable, then they have to be changeable. If then it is open. I think, Ashutosh, this is the concluding line. Yes, how they will change, who will be capable of changing it, in what situation, by what process, that's it. That's the next level.
Yes, sir.
I think Shresth has given a very big conclusion. Thank you, Shresth. Thank you, and thanks to all the panelists. Thank you, Ashutosh. Thank you, Krishna.
Thank you, sir. Yes, Reet, you can continue.
Thank you so much, sir, for
Thank you.
Thank you so much, everybody, for taking your time out. It was a pleasure for the entire society, for all of us to take your time out and come here and grace this discussion, and also our 3rd anniversary. Thank you so much.
It was indeed our pleasure to have you all on a panel today for providing our viewers a very insightful session. I would say that, as I said earlier, that this was going to be a detailed discussion, and it was truly an insightful to our viewers. Thank you so much. Thank you so much, sir, ma'am, to be here. Thank you all.
रूबी मैम कार में ही पहुंच गई. No issue, ma'am. Bye, ma'am.
Thank you, everyone. Thank you, Verma sir. Thank you, Tripathi sir.
Thank you,
Good job, Reet and
Thank
Krishna.
you.
So it
Thank
was
you
your
for
first
inviting
thing. So it was well organized. I hope so. Ashish sir, any comment on the organizer, Reet and Krishna? Sir, चले गए लग रहा है.
Sir, very
Okay.
well organized. I'll comment. I congratulate both Reet and Krishna for for duly acknowledging the 3rd anniversary of your society, and I think they've done pretty well. So congratulations to all of you.
Thank you so much, sir.
Thank you, sir.
Okay then. See you in the coming session then. Okay, Reet, close the
Thank
meeting
you
now.
so much, sir. Yes.
Just one thing, all the participants kindly fill the form we have sent you in the chat box. Thank you.
Thank you all.
कृष्णा एंड फॉर ऑल कर दो.